Thank you. Representative Corvese.
Thank you, Representative Craven, and the other representatives here for their comments. Representative Craven, obviously I support the bill. I'm just curious as a layman, and since you're a lawyer, I can ask you that directly. With regard to the language on page 3, and the first sentence of the paragraph, lines 10 through 12.
Yep.
Could that language, and I have no problem with the rest of the language, I'm just asking a question for my own edification. Can that first sentence be interpreted by the courts or law enforcement to mean anything other than the intention of the bill, which is to prohibit the bump stocks themselves?
That's a good question. You should have gone to law school instead of becoming a doctor.
You have no idea how many people have said that.
Especially the fingers thing like this. Yeah, that's.
That's just the habit. I'm sorry.
You can see that in Superior Court in front of a jury.
But I absolutely support the bill and the intentions of all the bills. And I appreciate the comments. But
That's language that should be worked on, Dr. Corvese.
Everything else I have no problem with. Again, I'm a layman. I'm just afraid that for the first sentence from lines 10 through 12, if that could be interpreted as anything else but the legislative intent of this piece of legislation.
Well, any rapid-fire device, you'll probably hear testimony later on tonight that there are other devices that actually operate as an addition to the internal workings of a gun that have other uses, and the people from the industry will talk about that. I'm sure with an intent to distinguish, as you have just pointed out.
And I wasn't aware of that, but let me ask you a question. Would you be willing, if there's a legitimacy to their argument, because again, the legislative intent of this bill is to outlaw bump stocks and the trigger device, which I have no problem with, but if it were to expand to other things not within the intention of the legislative intent, would you be willing to rework this?
Absolutely.
Thank you, Representative.
Any further questions for Representative Craven? Yes.
Thank you, Mr. Chairman. Representative Craven, going along in the same avenue that Representative Corvese had gone to, if you turn your attention to page 2, beginning with lines 28 through 30, some of my constituents had articulated the concern that it's talking about a device to include but not limited to the bump stock. And what was brought up to my attention is that sights, collapsible, let's see, forward posts, I guess it's called a collapsible stem. There are things that could be used for greater accuracy, safety, and control that would actually also potentially increase the shooter's ability to shoot rapidly if they're target shooting, for instance. And while they recognize that you're looking specifically for anything that would turn a semi-automatic weapon into an automatic weapon, the concern is that that language in lines 28 through 30 are a bit ambiguous and could also be construed as going after those items.
That's exactly the type of issue that Representative Corvese was referring to, because any time a but not limited to language creates the prospect of bringing in other devices, in some instances, I would presume, that have yet to be invented, or the uses have yet to be utilized of such a device. Mm-hmm. My intention is really only to focus in on any device that causes a semi-automatic weapon to operate as an automatic weapon, period. And if it has another purpose, I'm not a shooter myself, although I have taken an opportunity in preparation years ago to for these types of hearings before the Judiciary Committee, go to a gun club and actually fire some of these things and see what they look like and talk to some of the folks there, and it was educational. But I really just don't want a device that can circumvent Rhode Island General Law 1147-2 that says you can't have an automatic weapon.
Understand. So again, I would hope that you would consider
Absolutely.
adding as an exception, does not prohibit devices used for accuracy, safety, and control.
Absolutely.
Within the guidelines. And then, I'm sorry, you said that the grace period, if this law is put into effect, would be how long, please, sir?
Well, there is no grace period in this right now. It says effective upon passage, as we often do with bills that come from Ledge Council. There's clearly, there'd be a day that would come and then it would be inappropriate and certainly unworkable for the next day to have people throwing bump stocks out their window and disavowing knowledge of them. We need a grace period in a methodology by which people can dispose of these items and these devices if they have them.
And then hopefully, again, if it is signed into law, that the grace period would be long enough for an owner to be able to convert a binary trigger into a standard trigger. I have no idea what that entails.
Yeah.
I don't know how many people are gunsmiths that do that kind of work in Rhode Island, but I would hope that you would keep
Yeah,
that
of
in
course.
mind as well.
Of course.
All right. Thank you.
Thank you. Representative Knight.
Just thinking out loud, it might be worth some language that basically defines the appropriate operation as one trigger pull, one bullet.
Any further questions or comments? Yes.
Is it all right if I go back to Representative Canario?
Sure.
Thank you. Okay. Representative Canario, on page 2 in your bill, section B, where it talks about the individuals that would be eligible to petition the filings?
Yes.
Okay. When you say law enforcement, are you talking about just municipal law enforcement, state police, and so forth? Or would that also include SROs and campus security?
That would include police officers and state police.
All right. Have you given any thought as to whether or not, especially in the fact that the SROs in our secondary and lower grades are hearing a lot of what's going on from the teachers as well as the kids, or campus security? Is there any possibility that you would add them as part of your definition of law enforcement for the purposes of this bill?
Thank you for the question. Obviously, as I indicated earlier, I'm open to suggestions, but the reason why I was aiming at police departments and state police is because they handle those types of situations on a, I wouldn't say daily basis, but more often. So I'm just thinking out loud that if a situation was to arise on campus, I would hope that the local police department or state police would be called in to handle that. I just don't think campus police, for example, deal with orders such as this. I could be wrong, but anytime you deal with getting warrants and stuff like that, or issuing TROs, or in this case, these types of orders, I venture to say police departments and state police handle them on a more regular basis. But again, I'm open to this. It's not, but that was my main focus, because the one thing I don't want to do is I don't want to infringe on anybody's rights by mistake, if you would. I want to make sure that if this order is put in place, it's done by officers that do it on a more regular basis and have more contact with the judges on a more regular basis.
Also, in section 9-16, where you talk about the return of the firearms,
I'm sorry, where are you at?
section 9-16, and I apologize, I don't have the page. I had it on my other notes. One of the issues that had come up time and time again when we were speaking about the confiscation or temporary confiscation of firearms last year was the condition in which the firearms were returned to the owner. So what would be the standard be? Is that something that would be articulated in
Well,
this?
typically, in a police department, as it stands now, when we confiscate firearms, they're put in a safe environment in our evidence locker, if you would, and they are secured in a safe environment. It's not as though we confiscate like hundreds of these a week. I mean, this is something that's far and few between. So I don't think it would be a case where we'd have an abundance amount of firearms because of something like this. This is something that you have to keep in mind that would be very once in a while.
Final question. I understand the HIPAA laws, and so I'm assuming, and please correct me if I'm wrong, that if there's an individual that is going through any type of counseling with a mental health professional, if the mental health professional thought that this was an individual that could potentially be fall within the red flag, what, if anything, could that professional do? They have to do nothing? Can they report to someone without it being a violation of HIPAA laws?
I would have to defer to Bill on that.
Members of the committee, Bill Connell from Ledge Council. Just on that. The author doesn't really specifically address that. It's the people who can file this are again limited to it's limited to who can actually file this. So, if in terms of the HIPAA laws, we probably have to investigate that a little more to see what that particular scenario, a doctor receiving that. Obviously, there's some limits on what they can say, but I do know that, for example, if someone says they're going to commit harm or commit suicide, then there is an ability to go out and inform people and inform the police. There are some steps that can be taken. So this bill doesn't really infringe on it. At least we don't think it does.
I'm sorry, I didn't hear the last thing you said.
I mean, I certainly can investigate that point a little more and see how the interplay would be.
Yeah, the bill does specifically state who, either it has to be a law enforcement officer or agency, the Office of Attorney General, or a family household member or respondent. So it doesn't include doctors and so forth,
Right.
in the legislation.
Yes.
But the other thing you want to keep in mind too is, regarding the HIPAA laws, if a child or someone who has been disabled is assaulted, their doctors, I believe, have an obligation to call the law enforcement. But having said that, it's not spelled out in this bill that doctors can do that, but I just wanted to make that point.
Well, if after you do the research, you find that it would not be a violation of HIPAA laws, I would say to please strongly consider, if someone is articulating fantasies of creating mayhem with whatever way. I mean, listen, in Boston, it was a pressure cooker and BBs, so it doesn't just have to be a gun.
I totally, and you make a very valid point, and I just want to make the committee aware that when I sat down and I thought about this bill, I wanted to be very careful about infringement on people's rights and the HIPAA laws. And, it's a very complicated and sensitive issue, and I just wanted to be real careful with that. And again, I'm open to suggestions, anything that we can do to help protect ourselves and each other, I'm all for it.
Thank you. Thank you, Chair.
Thank you, Representative Ella Wilkinson. Representative Knight.
I took the opportunity to look it up. HIPAA allows for disclosure in these kinds of situations. So there's also a courtroom exception as well, so you can subpoena in a healthcare provider to testify on the issue, and state law allows that as well as HIPAA.
Thank you.
Representative O'Grady.
This question is for Representative Canario. Representative Canario, I've been contacted by some constituents who have due process concerns, and you alluded to how careful you've been in making sure that this bill treads carefully around due process. Can you explain how the travel of this petition to have a red flag protective order issued, how does that work? Does it, I mean, I know you've already delineated who can make that petition, but then, what is the judge's responsibility? What opportunity does someone have for a hearing, that sort of thing? If you could walk us through that.
So basically what happens with this is the person comes forward and makes a statement under oath, okay? They just can't, write out a letter of complaint and then hand it in. This is done under oath. So if anybody falsely puts in information, they can be charged, okay? It is a crime. So we wanted to protect the falsification part of it. And what happens is after that person submits the complaint, obviously it's interviewed by law enforcement, and the evidence is brought before a judge, and the judge is presented with whatever evidence there may be. And then the judge makes the determination if there is enough to issue the order or there isn't. These are very sensitive issues, and we want to make sure that the evidence that is presented is solid, evidence, and it is something that just wasn't fabricated. I mean, they look at a lot of things like, is it an ex-girlfriend? Is it an ex-wife with a grudge, or a husband, or whatever? So we want to make sure that when the evidence is brought in, it's brought in under oath, and they are fully aware that any information that is falsified is a crime, and they will be prosecuted.
And how about the issue of whether folks have the right to a hearing, or is there a hearing?
I'm sorry,
before a judge?
yes, they do have a right to a hearing. When it goes before the judge, it's scheduled for a hearing within 21 days of the complaint, unless it's an emergency situation where something's imminent about to happen. But they are given a court date, a hearing date.